Good morning. Good morning. Good morning, everyone. I'm just going to wait for some people to tune in. While you're tuning in, let me pull up some frequently asked questions. Today, I'm just here to answer questions, guys. So if you have any questions on immigration, I'm going to be on here for about 10, 15 minutes answering questions that you have on immigration matters. I know some people tuned in yesterday and had some questions, and I wasn't able to answer all. So please feel free to ask your questions today. If you're tuning in for the first time, comment in the box and let us know where you're tuning in from. I'm currently in Atlanta, Georgia. I'm based in Orlando, Florida. Our offices, our headquarters in Orlando, Florida. I'm in Atlanta for the week. As I mentioned, so I'm in my hotel room this morning going live. I represent clients in all 50 United States with their family immigration matters. So it doesn't really matter, where you're located. My phone number here is 407-995-6567. Okay, so let me pull some questions that I get asked a lot, so I can ask you guys, and if you, I can answer for you guys. Let me go back to, okay, good morning, Cecilia. You're up bright and early. I think it's like 8 o'clock in Indiana. Okay, so let's talk about some frequently asked questions that I get asked all the time. One of the questions I get asked all the time, is, what is better? Well, one question I get asked all the time is, if I'm a green card holder, and I get married, and my spouse has overstayed here in the United States, can I file for that spouse? So the answer is no. So generally, if you're a U.S. citizen and your spouse overstayed and came into America a specific way, meaning they came in with inspection, and there are no restrictions on their visa, generally you can file for them. But if you're a green card holder and then your spouse came into the United States, you can't file for them if they're an overstay. The only time you can file for them is if, while they're here, the visa is currently active for you to petition for your spouse, number one. And then number two, your spouse has not overstayed their visa. So you understand the difference. If you're a U.S. citizen, it doesn't matter if they overstayed their visa. If you're a green card holder, the person has to be actively have an active visa for you to be able to file for them. Okay, there are obviously, with everything immigration, there are obviously exceptions. An exception would be if, you're self-petitioning yourself based on your spouse being cruel or abusive to you. If you're petitioning by yourself, it doesn't really matter whether or not you've overstayed or not. You can file and you can do your adjustment of status. So that's how that works. So let me also talk about admission and entry, because I get a lot of frequently asked questions about that as well. And guys, as you tune in, please introduce yourself. Let us know where you're tuning in from. Ask your questions. I really do these FAQs. So, when I do them, this is a great opportunity to ask questions for me to answer. And then if you've not liked us or followed us, hit the like button, follow us, subscribe to our YouTube channel if you want to be notified whenever we go live, so you know what's going on. Oh, thank you for tuning in from Jamaica on TikTok. So I want to talk about just different admissions and what allows you to adjust status in line with what I just talked about. So there are certain ways you can enter the U.S., and how you enter the U.S. determines whether or not you're going to qualify to adjust your status. For those who don't understand or know what adjustment of status means, adjustment of status basically means that while you're in the United States, you can file and change your status from whatever status you are into getting a green card, right? So, for instance, if you come into the United States with a visiting visa, right, a B1 visa, B2 visa, tourist visa, you can enter, you can adjust your status, okay? If you came into the United States with a C visa, right, like a crewman visa, you know, or something like that, where basically what that means, for those who have never heard of like a C visa before, a crewman visa, what that means is that, you know, you got a visa to go like on a cruise ship, like go through a cruise ship. Basically, you're just passing through, you know, but sometimes, you know, some people are like, oh, you know, I'm in America, I'm not going anywhere. If you're in one of those situations and then you end up marrying a US citizen, you're not going to be able to adjust your status based on marriage because of the kind of visa that you came in with, okay? So based on, because, you know, you came with a C visa. So the only way you'll be able to, again, in that situation, obviously there are exceptions, is if, let's say, you know, you're in a bad marriage, you know, and you're petitioning for yourself because your spouse is, you know, cruel and abusive to you, then you'd be able to adjust your status in the United States. But otherwise, hi, Macadonas, good morning. It is so early. Do you not go to sleep? What time is it in Washington State? I think it's like 6 a.m., right? That's super early, but thank you for spending your morning with me. As I was saying, so, you know, a lot of times these people with C visas just come into the United States. And, you know, obviously for whatever reason that they choose to stay here, but a lot of times they don't know that even if they marry, they cannot adjust their status because of the kind of visa they came in with. If you have a C1, you know, visa, a crewman visa, you know, or anything like that, you want to make sure that you know what your options are. Now, if your spouse is abusive to you, then you can file for adjustment of status, even if you have that visa, and get your work permit and get to stay here. So let's talk about another category of entry. Let's say you enter the country uninspected, right? So you came in uninspected without, you know, you crossed the border, you came by boat, you know, basically no customs and border person inspected you. You don't have any documentation showing you're in America. You know, if you come in like that, you cannot adjust your status in the United States. So, and for all those different types of entry that I'm mentioning, when I say you cannot adjust your status, right? Because you cannot adjust your status doesn't mean you cannot get a green card. What it just means is that you cannot adjust your status in the United States. You're going to have to qualify for a hardship waiver. And if you qualify for a hardship waiver, then you go back to your home country and finish the process, okay? And then enter as a green card holder. You know, and for a lot of people, that is terrifying because you don't, you know, depending on what country you're from and the chaos going on in that country, you know, you don't know what's going to happen, right, if you go. So I understand the fear that a lot of people have with doing what we call consular processing, because you don't know if things will work, you know, or not. So that's why I'm giving you guys different options, you know, depending on your situation. So what did I just talk about? So again, talking about undocumented immigrants. When I say undocumented, the people that I'm talking about is there's no paper trail. There's nobody that knew you came into America. You crossed the border. You know, I don't use the word illegal because I don't believe any human being is illegal, but basically you entered without inspection, right? Sometimes we know it as EWI, which is EWI. In that case, you cannot adjust your status. However, again, an exception is if you qualify based on you being married to somebody who is abusive or extremely cruel to you, you can adjust your status. You can get your work permit. You can get your 10-year green card without ever having to leave the country. So as you can see, you know, a lot of these bans where they say, you know, you can adjust your status, you know, you can do this. When you have a marriage or a parent and you're a child, or you're a parent and you have a son or a daughter who's over the age of 21 as a US citizen, those are when the exceptions come in. If those people are cruel to you or mean to you. Okay, so those are some frequently asked questions that I get. Let me go through and see if there are any other questions here. Melissa says, good morning to the best lawyer I know. Thank you for helping immigrants. Oh, you're so very welcome. Tiffany from Bahamas, I'm still waiting on your call. Did you schedule a consultation? So we don't call you, you call us to schedule a consultation. So if you'd like to schedule a consultation, give me a call, 407-995-6567. Let's see. Yone Gale says, can I file for my son with a 2-year green card? Good morning, Yone. So yes, you can file for your son. So even though you have, and for those who don't know what a 2-year green card is, a 2-year green card is basically a conditional green card. And if you see me going up and down, because I have 2 screens, I'm on TikTok on one screen, YouTube and Facebook on the other screen. So I'm trying to give everybody some, face time. So you can file for your son. However, you want to make sure that you and your husband or your wife, whoever you're married to, are solid and that you're going to get those conditions removed. Okay? Because if you're not able to, then your child or your son will not be able to. But otherwise, you as a conditional green card holder can petition as though you were a green card holder for your minor children, or for your unmarried children over the age of 21. So yes, you can do that. Andrea says, yes, we have to be up for you. Thank you. Thank you. So Cabby on TikTok, I can't see your question. I see you saying he lives in the US, but I don't see the question that you're asking me. So if you want to ask me the question again so that I can be able to answer. Okay, so do you guys have any other questions for me? Today's just really, I don't have a topic for you guys. I'm just here to answer your questions. So if you have questions, drop them in the comment. You're welcome, Yone. You can ask them so I can answer. Okay, let me scroll and see. What else do I get a lot of? Oh, yeah, I know that there were some people that were asking me this question yesterday, and I didn't get to answer about yesterday I talked about, if your spouse is trying to sabotage you or try to, basically make you get denied, that a lot of times when you have sabotages and you query more, ask more questions, you find out that you're dealing with partners that are very controlling and might have tendencies to be abusive and cruel. And somebody asked that, okay, what about if they already have an interview scheduled, or if they already had the interview, but they're just waiting on the decision, can they still change their petition? Can they go from a marriage-based petition to a VAWA-based petition? The answer is absolutely. As long as USCIS hasn't made a decision, you can file a VAWA petition, and we can ask them to basically convert your pending petition to a VAWA-based petition. And even if you do get denied based on what it is that your spouse did at the interview, you can still put in a VAWA application, and there's your opportunity to unleash and give your testimony, give your declaration. And when I say declaration, I mean your testimony, but we just call it declaration. Give your declaration of what happened, in your marriage, and even down to that interview, address some of those reasons for those denial of, no, this is what my spouse did because my spouse is, abusive to me. My spouse is controlling, and, they did that because they didn't want me to get my green card. Yeah, so you can do that. So let me see if I have any other questions. Someone says, if you pay taxes without being legal, will it affect you when someone puts in your paper? No, you paying taxes shows that you're a good, that you have good moral character, actually. So the biggest thing when you pay, when you're in a situation like this that you worry about is to make sure that, I'm assuming that, you or the hypothetical, the person works under the table, right? So if you work under the table because you need to survive, right? Or you need to take care of your family, one of the caveats or the warnings I would give you is to make sure that you are not filling out any form that says you're a US citizen. Because that is like suicide. Like if you fill out a form saying you're a US citizen, you'll get denied because, sometimes they will go find that form. They will go to that employer, especially where you work for big employers who have what we call e-verify or I-9 and stuff that you need to fill out. Sometimes USCIS will go directly to that employer and say, let's pull this person's record. Let's pull this person's record and see what they listed on the form. So just make sure that you're not listing that you are a U.S. citizen. Let me stress that again, please, guys. Don't write that you're a U.S. citizen. There are many things that are waivable and they can forgive. That is not one of them. Okay, some people get ITINs, which is like an employee ID number, and that's what they use to pay their taxes while they're working. But you paying your taxes is not going to work against you, because it's showing that you're actively trying to be a part of the United States and you're doing your good moral duty of paying taxes on your income. So that's good. So somebody says, how can I file for my daughter and my son? I have an 18-year green card. Patricia, why do you have an 18-year green card when you can be a U.S. citizen? You need to file for your citizenship, because you don't ever want a situation, because guys, as long as you have a green card, your green card can always be taken away from you. So once you become eligible to be a U.S. citizen, just do it. Do it and be done with it, and know that nobody can take it away from you. Nobody controls whether you travel outside of the country, how long you spend outside of the country. So Patricia, the first thing you need to do is file for citizenship. Become a U.S. citizen. Next, can you file for your daughter and your son? So the answer is that as a green card holder, it really depends. You can file for your children if they are under 21. If they are over 21, you can only file for them if they are unmarried. So they cannot be married for you to file for them as a green card holder. Obviously, these exceptions don't apply if it's through marriage. So just keep that in mind, okay? But go get your citizenship, Patricia. Let's see. What options do I have if abandoned by my abusive wife? How long for this case? Many times she says she will call USCIS to deport me. She treats me like a slave. I'm abandoned in the house. Wow, I am so sorry that you're dealing with this. So friends, this is something that I can help you with. My phone number here is 407-995-6567. For those of you on TikTok, it's right there in my profile. You can also send a WhatsApp message with your phone number if it's local, for us to call you back to schedule you for a consultation. But if you are in that situation, friends, one of the things that you need to get qualified for is to see if you qualify for VAWA. If you qualify for VAWA, yes, you can file a self-petition to get your 10-year green card by yourself. Doesn't matter how long you guys have been married, right? Obviously your wife has left you. As long as if she has filed for divorce, we want to make sure that's under the 2-year requirement. But forget that she's threatening you and all of that stuff, because that is psychological stuff, that an abuser does, because they want you to be at their mercy and on your knees. So, you potentially have an option to get your green card by yourself here in the United States without having to leave. But, you would need to call so I can qualify you to see if you qualify. But, I'm really sorry that you're going through that. But, nobody should be a slave, in any house. Okay, guys, so let's see. Do you guys have any other questions for me? I have 5 minutes. So good morning, Smith, Barana. How are you? Okay, so do you guys have any other questions before I jump off? Okay, so somebody says, I got a stamp in my passport saying limited stay, no AOS, EOS, COS. My boyfriend is an LPL and we'll be getting married. Island girl, congratulations. So basically what she's saying is that, so when you get a stamp in your passport saying no adjustment of status, no EOS, let me explain what that means. AOS means no adjustment of status. EOS means no extension of status. And COS means no change of status. Basically, they're telling you you're coming in here temporarily and you need to be out, once your I-94 expires. But them saying that does not necessarily mean that you cannot do that. I mean, whether they stamp that or not, that is a general presumption when you come in here that you shouldn't be doing any of those things. Now, can you get married and file? Yes, you can get married and file still. However, because you're married to a legal permanent resident, you have to be careful of a few things. island girl. When you're married to legal permanent resident, you have to make sure that when you put in your application, one, the visa is available. Two, that you are currently within the time that you were supposed to be in here. So if, let's say, you came in June, let me use June. A lot of times they'll stamp you to be in here for 6 months. So I think the end of that would be November. So you want to make sure that when you put in your petition, you put it in before that expiration date in November in order for you to adjust your status. The second thing is you want to make sure that you're not marrying somebody within 90 days of being in the country. If you marry somebody within being in the country for 90 days, they're going to assume fraud or misrepresentation. They're going to say, you know, you saw this stuff on your passport, you knew exactly what it meant, and you went ahead and got married. After 90 days, you know, there's no presumption of that. Of course, you know, there's still high scrutiny, you know, to make sure that you're in a legitimate marriage and you didn't just marry somebody randomly. But after 90 days, there's no presumption. There's no assumption of fraud. It's just could be circumstance change. You know, you didn't come here to marry, and then all of a sudden you guys are like, you know, we can't live without each other. Let's just get married, or, you know, whatever the reason was. So those are the things that you have to consider and decide, you know, what is best for you and your family. Again, this is not legal advice. You have to schedule a consultation for legal advice. I'm just giving general hypotheticals. Okay, does anyone have any other questions? I have 2 minutes. 2 minutes. Type your questions so I can answer it before I jump off. And let me make sure I got everybody on TikTok. Yeah, I don't understand this question. Erica, thank you so much. Erica says you're great. Thank you so much. I appreciate it. Okay, somebody on TikTok says, I just sent my application. They returned it and said I filed an old form. What should I do? Man, oh man. You see, I just talked about that on my TikTok video yesterday, I think, where it said, you know, tips to send a properly accepted application or whatever it is. A lot of times, you know, people just, you know, think that immigration is all about filling out a form. It is not. You know, there are strategies to making sure that you package yourself and you present yourself well. Also, you know, you want to make sure immigration is very, very particular about forms and the addition. So, you know, the thing is, they don't announce that that there's a new form. They never announce that. You have to do your due diligence to find out, is this the latest edition? Well, that's number one that I'm sending. So DY for you, you need to go for whatever form it is that you're sending. You need to go and find out on their website, what is the latest edition of the form? What form should I be sending? Okay. Once you find that out, you send that out. Another common reason for rejection of applications is sending the wrong filing fees. You know, a lot of times people will send a money order or send a check and it'll be the wrong amount and you get your packet back. Listen, guys, the worst thing that can happen to you, especially if you're on a time crunch based on your status, is to send the wrong stuff, because it will take them like 6 to 8 weeks to send that stuff back to you. They won't create a case. They won't create a case for you, and then they would have to, you know, you'll have to do it again, and by then you might be timed out. So Guy says, you're right always, doing a great job. Thank you so much. You guys are so sweet to me this morning. Thank you so much. Oh, Jamaica Devon says, how long have you been practicing immigration? Well, I've had my firm for 5 years. It will be 5 years in October, but I've been a practicing attorney for 15 years. My actual background is I actually started out working on Wall Street, doing mergers and acquisition. If you guys know a little bit about my story, you know, my own personal journey with members of my family inspired me to get into immigration. You know, all of us were born in America except my youngest brother, who went through a really tough time, and it took about 10 years for us to get him his green card. And, you know, so that really sparked my interest in immigration and just seeing the pain of, you know, families being separated. So that's why I'm very passionate about it and why I talk about it, because, you know, I'm not just somebody who's reading a textbook. You know, I've experienced it myself. You know, my parents came into this country as immigrants who came here on an F1 student visa. And they had us, they had, you know, there are four of us. They had three of us here, you know, and as soon as I was 21, I filed for my parents, and my sister, I filed for one parent and my sister filed for the other parent. So, you know, you know, I'm not just doing the talking, you know, because sometimes, you know, I hear people say, well, you don't really understand what we're going through. Oh, you're an American citizen. Oh, you don't even know. But I know firsthand, you know, what you guys are going through, because I had to do the same thing for my own parents, you know, outside of my clients. I had to, you know, watch my own sibling, you know, go through what some of you guys, you know, go through. And, you know, I grew up, you know, for majority of my life outside of this country. So even though even though I was a citizen coming into this country, it felt like being a foreigner. So yeah, so long-winded story, but yeah, I've been practicing law for 15 years. I've had my practice for 5 in October. Okay. So, oh my goodness, it's 9:32. I have to jump off. I'm late for my meeting. Uche, you can ask your question tomorrow. Or let me see if I can answer real quickly. You're petitioning for your relative overseas. Are you required to pay the same filing fee for their minor children? The answer is yes. The only time that your filing fee is different is, let's say you're doing an adjustment of status and you're doing one at the same time for your wife and for your child. If you're doing it at the same time and your child is under 14 years old, your filing fee is going to be significantly different than, say, a child that's over the age of 14. And if you don't do it and you do theirs later, the fee will be a bit different, but a little bit higher. So it all, you know, it's all a toss up. So if I had a specific situation, I would be able to give it to you. Guys, I do have to jump off, but if you guys want to tune in again tomorrow, I'll be here tomorrow at 9-ish, somewhere between 9 to 9:05 a.m. And I'll be able to answer your questions. I hope you guys have a great day, okay? Bye.